Yes, please.
May I please your lordship. Lordship, I beg to mention item number 40 of today's list. Lordship, last week, Friday, the affidavit in opposition has been filed by the state. May I pray for 3 weeks' time?
Have you informed the other side?
State is the other side.
No, but I find a lot of names. Item 40.
40.
Yes, respondent 19, respondent number 5, respondent number 16.
Those are all the development authorities.
But they are respondents. They're lawyers representing them. If I give you if I allow this mention right now, they may be waiting for their matters. So you inform them and come. This court will accommodate you. There is no difficulty. Yes, next.
May it please your lordship. Lordship, with regard to item numbers 17 to 19 and 42.
One second.
Lordship.
17.
17, 18 and 19,
Yes.
as well as item 42 of the supplementary list. Lordship, pursuant to the Honorable High Court's order dated 25/4 of 2025, we were to file our affidavits by 28. We have done so, Lordship. My prayer is a small prayer just for calling the affidavits, Lordship.
These three matters are connected to item 42.
Yes, Lordship.
Okay. Call.
Pray for Lordship. Much obliged, Lordship.
May it please, Lordship. 32, my lord. Was called for, but that was not.
It is not available. Commercial quantity, Lordship. NDPS.
In item 32, scan copy or CD?
CD, Lordship.
Await CD, send reminder, issue reminder, not issue. You have to resub. You have to bring it, right?
Lordship.
Awaits case diary, list on such and such date.
Short date.
Next.
Mention item 21.
21. What do you want?
Case LCR has not been received yet.
Is
That may be
it
called.
Mr. Das?
NCB, Lordship. NCB.
Yes.
No,
It is not received. CD or scan copy?
Lordship, scan copy.
Item 22.
21, Lordship.
21. Await scan copy, issue reminder, list on such and such date. Await scan copy of so and so last order of the case records as called for, and okay, complete code was sent. Yes, please call the list. Not pressing.
Lordship.
Heard Mr. B. Deori, learned counsel for the petitioner. Also heard Mr. P. Das, na? AK. KK, sorry. Mr. KK Das, learned APP for the state respondent. Mr. So-and-so Deori, learned counsel for the petitioner, submits that he has been instructed by the petitioner not to press the instant bail application and accordingly seeks withdrawal of the same. Bail in view of the aforesaid endorsement made by the learned counsel for the petitioner, the bail application stands dismissed on being withdrawn.
Pass. Number 1.
22C.
Yes, Lordship.
Yes, notice and scan copy.
Lordship.
Case diary, Lordship.
Case diary.
Case diary.
Call for case diary. List when?
9th, Lordship.
Can you get it, Mr. Das?
Lordship.
On such list on such and such date. Case diary or scan copy?
Scan copy, Lordship.
Scan copy.
Scan copy, Lordship.
Issue notice. Let the scan copy from the court of special ND from the court of additional session judge.
Now, Lordship, is special judge Sri Bhumi, Lordship.
Where do I get the reference?
Page 22. 22, no?
Because it is better to write it in the order. It's
Then, Lordship, additional session judge Sri Bhumi, Lordship.
that's what I'm saying. So it will be from the court of
Additional session judge, comma, Sri Bhumi.
additional session judge Sri Bhumi in connection with the special NDPS case number 24 of 2023 arising out of the Ratabari police station case number 92/2023.
Yes.
Through the registry likhi diba. Yes, when?
On 9th, Lordship. Same date.
On list on such
High
and such
level
list. Case diary or Scan copy, case diary. Issue notice. Let the case diary be placed before this court on the next date of listing, list on such and such date. That call will be 13. POXO. POXO.
Yes, ma'am.
Huh?
Kindly for the scan copy, my lord. Issue notice, no, POXO is there, my lord.
I know.
Yes.
That's why I'm asking you, is it POXO or not?
POXO 8, my lord.
Issue notice, let steps for service of notice in respect of respondent number 2.
Yes.
Respondent number 2, who is respondent number 2? Informant or the victim?
Informant.
When stroke informant be taken through the registry of this court in terms of the decision of the division bench in the case of Deepak Naik versus so and so, huh? List on such and such date within a period of 2 days, 3 days from today. Huh? List on such and such date. 15 May. Case diary shall will also call for the case diary. Let the scan copy of the case records be also called through the registry of this court. C is there. Case diary or case diary. Issue notice, call for case diary, list on such and such date. NDPS, this is also commercial. Yes, next. Commercial quantity.
Yes, my lord.
Uh,
I kindly call for
Yes,
scan.
case scan copy. Issue notice, let the scan copy of the case records be called from the
My lord, additional session judge.
from
FTC
the
of Kamrup
Court of Learned Additional Session Judge FTC number 3 Kamrup Metro
Guwahati.
in Guwahati in connection with NDPS case number 193/2023 corresponding to NCB Guwahati crime number 3 of 2023. List on such and such date through registry corridor.
It's NCB crime number 9 of 23.
I read from the
What should have said 3 of 23.
Lekhilu. No, NDPS 193 aru NCB crime number 3 of 9. Thank you. Date dila? List on
14.
14.
Yes, my
All
lord.
right.
This is the Lordship. Lordship, I kindly finish page 33, my lord.
22C.
Yes, my lord.
Issue no scan copy. Issue notice. Let's scan copy of the. You want the first condition to be override?
No,
Huh?
no, my lord.
Why unnecessarily waste judicial time of the court? Let the scan copy of the case records be called for from the Court of Session Judge Karimganj arising out of in connection with special NDPS case number 115 of 2024 arising out of Badarpur PS case number 267 of 2024. List on such and such date.
May I clear one thing? Another quick is, my lord, approach this honorable court where trial court record is already there. So if that can be, my lord, tagged with this matter, perhaps that will suffice, my lord. That DA number 333 of 25.
Mr. So-and-so submits that the case records in connection with the aforesaid case is already in court in connection with
DA number 333 of
DA number
333, my lord.
333 of
2025.
2024.
25, my lord. 333 of 2025.
25. Let registry verify, and if the case records are so available, let BA so-and-so be tagged along with this.
DP of that. Nice.
But what has happened to that BA? You are appearing.
Yeah, yes, I have recently engaged, my lord, in this matter.
So both can come together.
Yes, ma'am.
POXO.
Yes, Your Lordship.
Okay. Heard Mr. A. Das, learned counsel for the petitioner. Also heard Mr. A. K. Das, learned APP for the state respondent. Issue notice, let steps in respect of
Call number 2, Your Lordship.
respect number 2, i.e.
The informant, Your Lordship.
informant be taken through the registry of this court in terms of hey Deepak Naik so and so within 3 days from today, list on such and such date.
Case there will be.
In the meantime, Nokoba, hey, issue je notice korisu tar upore koi diba call for case diary.
From the court of the folks.
Case diary.
Case there, Your Lordship.
Then
Oblige, Lord.
POXO. POXO.
Cancellation or paid, my lord.
But whatever, it's POXO. Oh, you are the informant.
Yeah, my lord.
Oh, you are the informant.
My lord, page 33, my lord.
All right, we'll issue notice. Issue notice. Case records, case diary will be required. Call for
My lord,
call for case diary. Let steps in respect of respondent number 2 be taken through registered post AD within a period of 3 days from today. List on such and such date.
15. Oblige.
There is also, my lord,
21C.
yes, ma'am.
Case diary or scan copy?
Scan copy, my lord, as it has been
Issue notice.
additional sessions just Sri Bhumi, my lord.
Call for scan copy of the case records from the Court of Additional Session Judge Sri Bhumi, Karimganj, in connection with special NDPS case number 89 of 2024, arising out of Ratabari PS case number 179 of 2024 through the registry of this court. List on.
Please, your lordship, my lord.
Yes,
My lord,
Mr.
here, my
Das.
lord, the petitioner's brother Mary speaks on, my lord.
FIR.
6-5.
FIR.
My lord, FIR is the page 17, my lord. Here petitioner's name is not there. My lord.
All right, short date.
We need
issue,
to file objection. We need to file one objection.
yes.
You file. I am not giving anything right now. I am giving you time. Huh?
Yes.
Issue notice, call for CD.
Fine.
Call for CD. List on such and such date. In the meantime, respondent may file, is at liberty to file objection if they are so advised.
On Monday, my lord. Next month.
Not on Monday. That
My
will
lord,
be.
because, my lord,
Can you have it by Monday?
Let us fix
1
on
week?
6-5, my lord.
It will take some time now.
Try to. You have a Tuesday. I'm giving you a week's time.
Tuesday.
Next Tuesday.
Much obliged.
Tuesday. List on
Okay.
such and such.
Tuesday की तारीख है?
POXO.
Only payment short date may be given, well, 61 years.
Notice has to ultimately be served. Issue notice. CD, call for CD.
13.
Huh?
13-5.
Call for CD, fixing it on 13/5 so and so. Issue, let's steps for notice in respect of respondent number 2 I.
So, office of the PP, my lord.
Huh?
Office of the
Informant or victim?
informant.
Uh,
Victim is a minor, my lord.
Informant be taken through the registry of this court in terms of so and so.
My lord, through office of the PP, my lord.
Mr. Counsel, please please kindly be alert as regards the notifications that are being out. You will get it. That notification has a procedure as how it has to be done. Please have a look at it.
Obliged.
13. NDPS commercial, my lord.
Call for scan copy or CD?
CD.
Call for CD. Issue notice query further. Call for CD and list on.
4740 notice is not there, my lord. So grounds of arrest, my lord.
Okay. Yes.
9th May.
All right.
It is not
Text.
there, my lord.
Fixed.
Obliged, sir. Very good.
FIR is not registered. Then
On the last occasion, instruction was sought for, lordship, whether FIR has been registered or not, lordship. We have not received instruction till now, lordship.
so then have it. Otherwise, I can dismiss it. What is the apprehension if there is no FIR?
We have not received information, lordship. Let it fix on tomorrow, then, lordship.
Tomorrow.
Lord.
Get it.
Let it.
Mr. A.K. Das, Leonard APP for the state seeks a short accommodation to apprise the court as to whether any police case has been registered against the petitioner or not, in terms of the last court's order. Prayer is allowed. List tomorrow. POXO,
Yes. Also matter.
issue notice, call for CD, call for CD and let steps in respect of respondent number 2. 2 is the victim.
Informant.
Huh?
Informant.
Informant be taken through the registry. Huh?
15.
List on
15.
hey, call for CD fixing on 15. তাতেই কৰি দিবা। Yes, essential commodities.
Yes, madam.
FIR, Mr. Biswas? Huh?
Essential commodity available, madam.
Yes.
But there are other sections also there. That's why it has become not
Okay.
available.
Let
What happened?
let us see.
I take your lordship to FIR page 11. There is allegation in 2023, my lord. There is allegation of shortage of petroleum products from a tanker, which was
This
started from.
FIR is of 23.
Yes, madam.
Huh?
Yes.
23.
Yes.
Yes.
And the FIR name accused person, driver, handyman, all have been arrested and are enlarged on bail. Now, but after 3 years, now one Sonaula was also, whose name is in the FIR, was also asked to appear. He has been granted pre-arrest bail by the Honorable Court, page 13. Now, my lord, police is asking me to come to the police station. I am a neighboring people, my lord. And that's why out of here, I'm ready to go appear.
Which is the notice? Are you named in the FIR?
No.
You are not named in
No.
the FIR. By which notice you have been asked?
No, not noticed by. They're asking me to appear, madam, not giving any notice, madam.
Then how do we know you're not even named in the FIR?
Otherwise, why should I come before your lordship?
You
There is
don't
apprehension.
know.
Because I'm
Mr.
willing
Das.
to go and help your lordship. In a similar case, the Honorable Court has granted complete.
Where have you said this in your petition?
Yes, I'm saying. I have said, madam.
You have
In this
to.
case, CD need to be there, lordship.
Huh?
CD need to be there, lordship.
CD, call, give me protection. I CD.
No,
Your
lordship,
lordship can call.
his role can only be ascertained after.
Correct. So where is the paragraph?
My lord, paragraph 6, the petitioner stated that after a lapse of 2 years, suddenly police visited the house of the petitioner, and as he was not present at the house in that moment, the police has instructed the family members to ask the present
Mr.
appear before the
Das,
police station.
you have said this. Let him be on interim till the next date. If there is anything, we'll
Yes,
cancel
your
it.
lordship can believe.
His name is not there. It's already 2 years have gone. The other accused have all been arrested. Maybe that one of the arrested person have said something. Could be.
Even if it is a belated stage, my lord, and it has got no evidence.
All right, Mr. Biswas.
Yes.
I'm giving it.
Yes.
Or you want me to adjourn it?
No.
Heard Mr. S.C. Biswas, Learned Counsel for the petitioner. Stop. Also heard Mr. A.K. Das, Learned APP for the state respondent. This is a application under section 482 of the BNSS 2023 seeking pre-arrest bail in favor of the accused petitioner in connection with the case in connection with Bongaigaon PS case number 458/2023 under section 379-381-406 of IPC, read with section 7 of EC Act. Stop. Mr. S.C. Biswas, Learned Counsel for the petitioner, submits that the FIR is dated 30/10/2023 and after almost 2 years, suddenly police visited the house of the petitioner, and as he was not present in his house at that moment, the police instructed the family members to ask the petitioner to appear before the Bongaigaon police station. So, stop, huh? He further submits that since the petitioner is not an FIR named accused person, however, in view of the said development, he apprehends that he may be detained and booked behind the bar if he attends to the police station, and accordingly has filed the present anticipatory bail application. Stop. Mr. A.K. Das, Learned APP, submits that the case diary be called for to ascertain the role of the petitioner for in the alleged offense. Stop. Considering the facts and circumstances of the case, to be Interim pre-arrest bail How much?
21st May.
Huh?
21st May.
No, no, how much bail bond?
Bail was 50,000.
If, huh?
20 earlier case
Huh?
20.
50? 25.
Lot.
No? Arresting authority.
Yes, yes, that's correct.
And you appear before
Yes, yes. Within 10 days.
10 days. 10 days are failing which.
Deep left.
And call for case diary likhila ningi. Tar uporot likhi dia. Call for case diary, fixing it on
21st May.
21st May. Tar pisot considering bili hetu.
Development.
In these cases, Lordship,
Just
in
a
two
minute.
cases, we have filed the affidavit.
17 or 14.
Just a minute, Mr. Saika. Which one is this? Item
17 to 19 along with item 14.
17 to 19. Oh, this is where in the morning you had said you had filed something.
17 or
You had filed it today, Mr. Saikya.
We have
by the health department.
health department.
No, in the morning, someone made a mention calling for, is that the affidavit,
Yes, sir.
which was,
That was it.
all right. Yes, Mr. Saikya.
Whether they would like to give a reply or not, I do not know, Lordship.
Yes,
Give
Mr.
a
Das,
reply, Your Lordship.
you will give a reply. All right. Heard Mr. D. Saikya, Learned Advocate General, assisted by Mr. B. Gogoi, Learned Additional Advocate General for the state. Stop. Also heard Mr. D. Das,
DJ Das.
DJ Das, Learned Counsel appearing for the petitioner. Stop. Mr. Saikya, Learned Advocate General, submits that an affidavit in opposition has been filed today. Today or yesterday? Has been filed yesterday
Item 17 and item
I-
15.
in WPC 2137 of 2025 and item
135.
item
Item 42. Supplementary.
and WPC 2135 of 2025. However, the same is not available on record. এতিয়া আহিলে নেকি record? তেতিয়া এইটো নিলিখিব হা? Mr. D. Das, learned so and so seeks how much?
What's your 1 week?
1 week time to file rejoinder against the aforesaid affidavit in opposition. Prayer is allowed. List on, yes, Mr. Saikya,
Yes,
Mr.
because
Das,
there is an interim order running
when-
the, 6th of May.
on 6/5/2025.
Lordship, instead of 6th, yes, let it be on 6th.
6?
No, 6th. 6th. Highly obliged.
Yes.
Interims, Your Lordship. that is
42 to একেলগে গোটেইকেইটা একেলগে মাৰি দিবা. Yes, interim is there.
In
Interim,
one cases which was running from before.
interim, if any, shall continue till the next date of lecture.
Lordship, highly obliged.
Yes,
Yes.
records have come, scan copy.
Lordship, regular bill and Lordship, commercial quantity in NDPS, Lordship.
Yes.
Lordship, ground for bill, Lordship, I filed additional affidavit. Here in this case, Lordship, ground of arrest was not communicated, Lordship.
I was expecting that a series of such cases will now come. All right, where is your affidavit? Additional affidavit to us?
Lordship, Page 42. From 42.
Page?
Lordship,
Yes.
at page 43, I have.
Yes,
stated.
yes. No, but you have simply stated nothing has been annexed.
Because copies have been provided neither to the petitioner nor to
Mr.
the
Parasa,
family.
have you seen?
I have gone through the record, my lord. Record, yes, otherwise.
Does
my
it
lord,
indicate?
Otherwise, I have flag marked the notice, my lord. Notice is there, but regarding the ground, it was not.
Except the case reference and the, nothing is
And,
there.
Otherwise, my lord, commercial quantity, these are the things, my lord, 17 witness in the search sheet. And
When was the arrest?
This was
Arrest
made on.
8/6. Forward on
8/6.
8/6
Today is
6 of?
295 days. Yeah,
Four.
8 June of 2024.
2024. And till now, how much days?
95 days.
5. Trial have started
Lordship.
Yes.
Sir.
3 witness examined, my lord,
out of?
17 in the search sheet. Search sheet submitted on 29th of November 24.
So you have flagged the
My lord,
notice and the
notice only, otherwise, my lord.
এইটো কালি মই এটা কাবাক দিছিলো সেই প্ৰণৱ কালি এটা ফৰ্মেটত দিছিলো সেই একেটা ফৰ্মেটতে কৰি দিব পাৰিলাহেঁতেন এনিৱে লিখিলো It's not there.
17 out of 17.
What is to be done, Mr.
At this
Parashar? It's
stage,
a
Malad,
constitutional
if-
fundamental right.
If something not come from,
You and I cannot help the situation. We can only expect that in
Well-
future, the arresting authorities are more.
but nowadays,
Vigilant.
we have seen Malad in the BA.
But I was, in fact, the other day, I think Mr. Gogoi was here,
Yes, 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 yes.
PP. And I was telling him that I think it's time where you sensitize the
Well-
investigating officers, because you see, because of such lapses,
Yes, nowadays, Malad,
the constitutional court becomes helpless, despite
only
materials being
retrospective. I've
there
seen Malad.
that, to believe, and especially in these special
NDPS.
acts.
Yes, yes, special.
As you have said, there are materials, but
There are
that
material.
will not now, one cannot ignore the constitutional
Malad.
protections, the rights guaranteed, right? So, and also that in case these officers don't follow, then you must come up with some
Yes, yes. Nowadays, of course, Malad,
guidelines
nowadays, of course,
to
Malad,
hold them accountable. Because if you don't do that, it will go on.
it is-
You and I will,
it will be
you
helpful.
see, you will not be able to argue, isn't it?
Malad.
Your name?
SK Singhal.
SK?
Singhal.
Heard Mr. SK Singhal, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned APP for the state respondents. This application is under section 483 of the BNSS 2023. Seeking regular bail in connection, bail in connection, bail for the petitioner, Joharlal Morang, who has been arrested on 8/6/2024 in connection with North Lakhimpur PS case number 152/2024, registered under section 21C and 29 of the NDPS Act, arising out of GR case number 400 of 2024. Stop. The brief facts of the case. Paragraph 2 to DTBA. Honor pra. That is that on so and so. It is DTBA. Mr. No, 1 second. Accordingly, the instant bail application has been filed. Mr. So-and-so, learned counsel for the petitioner, submits that the arresting authority, while arresting the petitioner, has not informed the grounds of arrest to him, and as such, the fundamental and constitutional rights guaranteed to him has been totally infringed by the arresting authority. Stop. He accordingly submits that the petitioner is entitled to be released forthwith. For contra, Mr. So-and-so, learned APP for the state respondent, fairly draws the attention of the court from the case records. The notice issued under section 50 CRPC to the petitioner, as well as the memo of arrest, which does not indicate that the grounds of such arrest has been informed to the petitioner at the time of his arrest. Stop, huh? Then, heard Perus Tebudidiba. Then you write. The primary ground urged in this bail application is as regards non-compliance of the constitutional and fundamental right of the guaranteed under the Constitution, under Article 22(1) of the Constitution of India. Apt to refer to Article 22(1) of the Constitution of India, which reads as hereunder, quote unquote. A perusal of the aforesaid provision abundantly demonstrate that an arrestee has that the Constitution guarantees an arrestee abundantly clear that the arrestee has a constitutional and fundamental right under the Constitution of India to be informed about the grounds of his arrest at the time of his arrest. Stop. In the present case, in the present case, apt to refer to the notice issued to the petitioner under section 50 CRPC, which reads as hereunder. Read Paba, records are quote unquote koi diba, huh? Flag eta lagai disu, orange color. Okay, tick mark koi disu. Perusal of the aforesaid notice indicates that except the name of the accused, case reference, no other information as regards the offense or the grounds of arrest is intimated to the petitioner in this notice. There are two petitioners.
One petition.
What is his name?
Joharlal Morang. Joharlal Morang.
But otherwise, there are more than one accused.
Yes, no.
A
Other
orange
accused
flag too. Juntu ase he today. Aru ase card. And arrest memo too. Jogolal Morang, na? Apt also to refer to the memo of arrest, which reads as hereunder, quote unquote. Reference of the memo of arrest also indicates that except the name and particular of the petitioner, comma, date and time of arrest, comma, no other information, comma, case reference, no other information as regards the offense or the grounds of arrest is mentioned. Similarly, the inspection memo, which is also reproduced hereunder for re-reference, does not indicate any particulars as regards the offense being intimated to the petitioner. Quote unquote, orange flag. A tick mark koi disu tinta. It is a settled law that non-compliance of the constitutional and fundamental rights guaranteed under Article 22(1) of the Constitution of India shall vitiate the arrest and stop. In the present case, it is absolutely clear that the arrest is illegal and hence vitiated. That being so, this court cannot keep the petitioner detained any longer in the custody, and as such, the petitioner is liable to be released forthwith. Accordingly, bail conditions can be NDPS allowed. Return. This is scan copy, no? What is this?
It is your lordship.
Yes. 22.
Yes, 22.
Yes, Mr. Datta.
Here also I have similar grounds that the grounds of arrest were not.
Scan copy. Yes,
Received,
Mr. Sharma.
Scan copy has been received, but the.
Have you seen?
Yes, Lordship, the additional affidavit has not been filed.
But I have the.
The scan copy is there.
Yes, Lordship, it is there.
If it is not there, it's not there.
Okay, Lordship.
Why should go into this technicality?
Certified copies also here
Of what?
of the arrest memo and.
That's all right. The scan copy is here. it would Mr. Datta hobo. S, right?
Yes.
Heard Mr. S. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma.
Yes.
Learned, you are appearing as standing counsel NCB. No, sorry. It is
22 Lordship.
22.
22 PPF.
Learned APP for the state respondent. Stop. This is an application seeking regular bail under section 483 of the BNSS for releasing the petitioner on bail. Petitioner I, Basudev Das and Rahul Das, dujon ase ne, who were arrested on 6/10/2023 in connection with Bozori Chera PS Casino 204 of 2023, registered under section 22C 2529 of the NDPS Act. Corresponding to special NDPS case number 131 of 2023, pending before the Court of Session Judge Karimganj. The brief facts of the case, paragraph 2 to read about. Episode paragraph 3, Mr. Doctor submission to he agor same hobo, Ekhetor submission to same hobo. Then heard, so scan copy. Have you flagged it? Where is it? Sharma, you have not flagged it. Just flag it and give me the certified copy. Go Nanok. Arrest memo. Same কথাটো লিখি দিবা. Two arrest memo আছে. So arrest memo of petitioner number 1 and petitioner number 2 বুলি কয় একেলগে দি দিবা তাৰপিছত perusal to হে একেটাই হ'ব except name আৰু place of arrest and হেগিটা বস্তু then first that I think notice to koba notice issued under 50 CRPC to both the petitioners, first notice and then the arrest memo, and then last one inspection memo, same thing and baki khini sab same thakibo. And duta petitioner, so bail bond 50,000 agor to etu ekhi rakhi allowed. Yes. In any of the NDPS case, similar ground is taken.
In this case, Lordship.
No, 1 second. Yes, which is your 24. Let us have 24 first because before the stenographer is changed, it will be easy more for me to just give this. If there is any more counsel who is taking the same ground, may mention it to the court master so that at one go I can finish it. Yes, Mr. Sharma, have you seen it?
Lordship, this has been done by KK Parashar Lordship.
Where is he?
He has flag mark Lordship.
All right. You have filed any additional affidavit?
Additional affidavit.
Where is it? Mr. Sharma verify korbo diyo.
Yes, got it.
To me, my easy hobo. Additional affidavit, I don't know. Page?
Page 38 documents are there. 38, 39,
Page 38.
38, 39 and
Page 39 is some document, but this is
arrest memo, notice, and then inspection.
no, it to me 23 Disa. Rupa, this is 23, 24 today. I'm taking up 24. Yours 24, right?
24.
I think a wrong. Mr. Parashar is there, I think. I'm taking up 24 first, Mr. Parashar, because the same ground is urged here. You flag mark.
1770 bottles were seized, commercial otherwise, but that
Same ground.
seems down.
You have flagged it?
My lord, sir.
ইয়াৰ পৰাই দি দিলে ইজি হ'ব, ইয়াতে আছে। Additional affidavit and মই কৈ দিম ৰবা। First that heard Mr. So and so KK Parashar APP. This is an application under section 483 of BNSS 2023 for granting regular bail to the petitioner i.e. Hafizur Rahman in connection who was arrested on 19/1/2024 in connection with Jogi Gohupa PS case number 13 of 2024 registered under section 22C of NDPS Act. The brief facts, paragraph 2. Our last one, hence the history. Our submission, Mr. So-and-so, same. Mr. KK Parashar, same. Next paragraph also same. Now, baki same kore diba. Aru a arrest memo you will get at page 38. Sorry, first the 50 notice you'll get at page 39. Arrest memo at page 38 and inspection memo at page 40. 50,000.
Brief of the fact is paragraph 3, Lordship.
Paragraph 3.
Lordship.
Paragraph 2. Oh, sorry, you're right.
Yes,
3. Thank you.
obliged.
Disposed of it. 29 is same. Yes, come. পাৰিবা নহয় প্ৰণৱ, এইকেইটা সব একেই কাৰণে মই তোমাক দি দিছো। Will you be overloaded?
I have filed, my lord, I have filed an affidavit.
1 second, who is you have gone through?
Item 29, Lordship.
Yes.
Yes, Lord.
Yes,
My lord, I have filed an affidavit bringing on record the arrest memo as well as the notice.
yes. Page,
That page starts at page 30, my lord.
page,
30 of my affidavit. my lord.
no, that I've got. Where is the arrest memo here? And next?
Find there,
Yes,
at page
yes,
34,
yes.
34 and
All
35.
right. Same, Mr. Das.
Lordship, sir. I have flagged Magid.
I'm referring it from here. He's annexed it.
Lord.
Heard Mr. T.N.
Srinivas.
Srinivasan, learned counsel for the petitioner, also heard Mr. KK Das, right? Kobat AK really likhi disu de. Sorry. You feel free to correct me.
Lord.
I get very confused with the initials.
Lordship.
KK Das, learned APP for the state respondent. This is an application under section 483 of the BNSS 2023 for granting bail to the petitioner, petitioner naam to Didiba. Sonu,
Sonu, my lord.
Sonu, petitioner I Sonu, who was arrested on,
2/6, my lord, 2nd of June. 2nd of June.
was arrested on 2/6/2024 in connection with Bazari Chera Police Station case number 100 of 2024, registered under section 22C, 50C/25/29 of NDPS Act so and so, and now and presently pending trial before the District and Session Judge Karimganj, Assam, in special NDPS case number 61 of 2024. The brief facts, para 2, and then Mr. Srinivasan, Mr. Das heard perused, and bakikhini aki likhiba. Notice as page 34. Arrest memo at page 35. Okay, yet inspection memo to 9. Inspection memo is not there.
I think it is there, Lord.
গোটেইকেইটাতে এটা লাষ্টত লিখি দিবা যে it appears from the materials placed before this court that there are no materials available in the case records to indicate that the grounds of arrest has been informed to the petitioner at the time of his arrest. এটা কেছত দুটা আছে their arrest.
And we want to
This,
point
this,
out,
this
point out only one thing, Lordship.
Yes.
He is the person from Uttar Pradesh, Lordship. So one local surety should be there, Lordship.
My lord, that,
a-
my lord, I have a submission.
one second. Inspection memo is there. I can't find it. Even if it is, because the arrest memo also doesn't say,
Okay.
because in the, generally it is mentioned as per inspection memo.
Okay.
That is not there.
Okay.
Yet nalage inspection memo. Bail bond 50,
50,000.
50,000 with one local surety.
Local surety.
My lord, let it not be local surety, my lord. Let it
Okay,
be surety,
has
my
been
lord.
done.
Yes,
Cash,
next,
cash surety. my lord.
next.
Right.
29 আছিল না? Any more? Same? No.
23. May I please, your Lordship?
We required 1 week time to file our written objection.
Can copy has come. Why you have not taken this? It's pending from March.
We have communicated to the.
1 week.
Not received.
I leave it up to your Lordship.
How many days?
3 years, almost
years.
4 years, Lordship.
What is this?
3 years, 11.
Why
3
you
years, 10
need
months.
another week's time? No, in fact, notice was issued February 28th.
Yes, Lordship.
Yes. Why you have not filed any objection till now?
Lordship, we have not received it from the department.
4 years is coming, is going to be 4 years.
Short time is required, Lordship. 1 week.
You have to be careful. It's a prolonged case of a prolonged detention. You cannot go on like this. You have to also take it up seriously. Mr. So-and-so, your name?
Agent
Agent.
on behalf. of
Learned
the
counsel for the respondent seeks 1 week time
1 week time.
for filing an objection. It appears that the petitioner has been languishing in jail for the last
3 years, 10 months.
3 years, 10 months. However, as a last chance, the respondent is given time till Tuesday, Monday,
No.
till Monday date till so and so to file their objection. If the failing which the matter shall be proceeded in accordance with law. List on such and such date. Listed on Tuesday. Let him file on Monday. I'm listing it on Tuesday.
I'm deeply obliged, Lordship.
If the affidavit is filed on Tuesday, one of you please call for it.
Lordship. Much obliged.
Yes.
Maybe Lordship, my lord. The petitioner, Bihur Lordship, was arrested on
10 copies there.
on 22nd of October 2024 and 188.
No, some legible scan copies were called for. Has that come?
Also, we'll file our objection today during the course of the.
Why till now not filed?
My lord, evidence of victim already been recorded. And if the.
Anyway, he wants to file
They will file, Lordship.
uh,
Let the matter come up.
as prayed for by Mr. So-and-so, learned counsel for the respondent.
Yes, Lordship.
List this matter on such and such date, 1 week or Tuesday, but Wednesday did you have Tuesday both get a case fix on Wednesday to enable the respondent file objection in the matter.
Already, my lord, 180 days may record, my lord, 180 days.
Next.
Yes, sir.
POXO. Last occasion also there was no representation. Who is appearing for the informant?
Informant,
Service report is also awaited.
notice awaited. Notice.
None appears for the petitioner on call. Await service report in respect of notice issued to respondent number 2. Respondent number 2. What about up-to-date case diary that has come?
Service, the series up to that one.
Should we appoint an amicus for the petitioner?
Maybe. Can be, otherwise, after service, but
Okay, let us see. A list on such and such date. Intermediate quantity?
Yes.
Yes.
For 55 days, your lordship is
50? 55 or 455?
55, only
55. 60 days.
60 days.
Yes.
Yes, Lordship.
can be a session.
Can be given, I think.
Lordship.
কালি এটা ইন্টারমিডিয়েটৰ তুমি পাইছিলা এটা সিমিলার টাইপ কৰি দিবা হা মই এটা দি দিছো বাৰু heard Mr. So and so learned counsel for the petitioner also heard Mr. B Das B Sharma learned APP for the state respondent. This is an application filed under section 483 of the BNSS for releasing the accused petitioner i.e. i.e. Jahangir Alam and Rakibul Islam who were arrested on 5/3/2024 in connection with Silchar PS case number 207 of 2025, registered under section 21B 29 of NDPS Act. The brief facts of the case is that paragraph 3. Okay. Mr. So and so submission to Didiba that আগৰ হেতুৰ নিচিনাই হ'ব 55 days in languishing in jail and mandatory period is coming to an end on within 5 days. হেতু তাত চাই ল'বা and intermediate term যোনটো একেটাই হ'ব submission আৰু per contra হেতু একেই submission দি দিবা আৰু বাকিখিনি সব same থাকিব bail bond কিমান দিছিলো 50,000
Will be to the satisfaction of special judge Kasari. Will be to the satisfaction.
Okay, satisfaction special judge Kachar Silchar. 27 kolo na?
Yes.
Satisfaction kita bhalke saba heru kuat thaki gole digdar hobo ha. Yes, Mr. Shekhar? Sorry. Yes.
May I please, Lordship. Lordship, I am moving this instant bail application as I was arrested under section 21C of the NDPS Act, Lordship.
Can copies available?
Yes.
Yes.
Thank you, Lordship. Lordship, I was arrested on the 28th October 2023, Lordship, at Lahorijan Police Station, Lordship. And the complaint was filed by one SI Nitul Saikia of Delhi Police Station, Lordship. The FIR of which is annexed in Annexure 1, Lordship, page number
Yes.
12 to 16, Lordship.
Contents.
Yes, Lordship. The contents, Lordship.
You are Mr. Wapangla.
Lordship Wapangle, Miss Wapangla.
And you are
Nikato, what's our Lordship?
contents page.
Yes, Lordship, page number 12 to 16, Lordship.
Contents of the FIR.
Oh, the contents of the FIR, Lordship, just give me a minute.
Yes, page 15, I think.
Yes, Lordship.
Yes, please read.
I have the honor to inform you that today on 28/10/2023 at about 5:10 p.m. an information was received from ASI Debojit Bhuiya, IC Lahorijan PPPS Delhi regarding detention of one suspected.
Just one second. On করে Yes,
Yes,
please.
Lordship, if I may continue, Lord.
Yes, please.
One suspected to be drugs carrying white color XUV 300, car bearing registration number AS 26E 2081, which was coming from Manipur side. Immediately, I informed the matter to Sri Rustam Raj Brahma, AAS, SDPO Bogajon. Accordingly, self SIUB, Itul Saikya, OC Dilai PS, along with SIP Sarat Kakati, ASI Dependas, along with staff, left Dilai PS towards Lahorijan by government vehicle, along with NDPS kit, that is digital weighing machine, metallic seal, sealing equipments, etc. In this regard, a GDE was made at Dilai PS, white Dilai PS GDE number 017, dated 28/10/2023. After arriving on NH 36 at Lahorijan PP, the following police personnel were ready to conduct search of the detailed vehicle. Team of police personnel. Number one.
You are?
Yes, Lordship.
You are Mr.
Anash.
Huh? Mohammed Anash. In the list of, okay, these are the accused. Yes, go ahead.
Yes, Lordship. The team of police personnel. Number one, SI Nitul Saikia.
You don't have to read out all
Yes,
that,
Lordship.
Mr. Counsel.
Lordship.
Kindly come come to the next page.
Yes.
At about 7:10. Read
At about
that.
7:10 p.m. on searching, I have recovered total 50 number of soap boxes containing packets of brown color powder suspected to be.
One second. Start from after obtaining the last, at page 15, the last paragraph.
Yes, Lordship.
After
After
obtaining,
obtaining authority from SDPO Bogajan, I have searched the above mentioned car and the body of the suspect, complying the provisions of 165 CRPC and 50 NDPS Act in presence of the above mentioned independent witnesses and under supervision of Sri Rustam Raj Brahma, APS SDPO Bogajan. At about 7:10 p.m. on searching, I have recovered total 50 numbers of soap boxes containing packets of brown color powder suspected to be heroin were found hidden inside the AC and music system slot and right side of the rear portion of the XUV car bearing registration number AS26E 2081. Out of the 50 numbers of soap boxes, 11 numbers of soap boxes recovered inside the AC and music system slot and other 39 numbers of soap boxes recovered from right side of the rear portion of the car. The powdery substances found inside the soap boxes was subjected to field test by me on the spot with the help of drug detection kit in presence of witnesses and SDPO Bogajan, and the result were found to be positive for heroin. I have measured the weight of the recovered total 50 packets of suspected heroin with the help of a good condition and accurate measuring capacity digital weighing machine and found the total 637.28 grams.
where are the names of the persons mentioned?
Yes, Lordship.
Where are the names of the suspect, the accused mentioned here?
The accused, Lordship.
Where is it mentioned, Mr. Sharma?
Lordship.
I can't find the name. This is the FIR. It
Yes,
says the body of the suspect. Huh?
Last paragraph, Lordship, page 16,
Last paragraph.
last paragraph.
Mohammed Anish.
I therefore request, yes, Lordship, the last paragraph.
All right. So this shows that it was from his possession.
Yes, from the car.
Yes, Lordship. Lordship, I have 3 grounds, Lordship. I had filed this application on 3 grounds, Lordship. The first ground being, Lordship, there was no conscious possession, Lordship. As Lordship, it is very clear from the records, Lordship, that I was merely a driver, Lordship. I was only a driver of the vehicle, Lordship.
All right. Second ground.
The second ground, Lordship, is that there is undue delay of the trial, Lordship. It is almost 2 years, Lordship. The witnesses have not been examined yet, Lordship.
2 years.
Yes, almost 2 years, Lordship. It is
You have
almost-
been in jail for?
for about 500. I may not be accurate, Lordship, but it is about 545 days, Lordship.
Almost 2 years.
Yes, almost 2 years, Lordship.
2.
Yes, 2 years, Lordship. Almost 2 years, Lordship. It is about
Yes.
545 days.
Next
Lordship.
round.
Next round is, Lordship. There was non-compliance of mandatory provisions, Lordship, under section 41, 42 of the NDPS Act, Lordship.
Section 41
42 of the NDPS
and
Act.
42. See, as far as your first 2 grounds are concerned, I am afraid I will have to reject it
Lordship.
because these are essentially factual matters which has to be proved during trial.
Lordship.
This court at the stage of granting or rejecting the bail application cannot go into all this.
Lordship.
This court is bound by section 37.
Lordship.
This is commercial quantity.
Lordship.
So it's bound by section 37, right?
Lordship.
The rigor of 37, as you know, the
Lordship.
test is to see whether there are reasonable grounds to believe that you are not guilty. Now, the fact that it has been seized from your possession is sufficient
Lordship.
to draw that presumption,
Lordship.
correct?
Yes.
So how can this court, of course, you will get the chances to rebut all this,
Lordship. Lordship.
but that is the trial stage. I am not convicting you.
Lordship.
I am bound by this. And you are you in this case you are there for 2 years. There are cases where 3-4 years in cases of NDPS. Now NDPS
And just add Lordship, altogether there are 9 PWs and 6 has already been examined, Lordship.
9 PWs,
6 have already been examined.
6 examined,
They have already implicated, Lordship. The evidence is before your Lordship.
implicated.
Implicated, Lordship. And we will not go into the merits of the case,
Correct.
but Lordship.
Anything more, Mr. Sharma?
Next date is fixed on 5/5/25
5-5?
for evidence for remaining PWs, Lordship. So at this
Sorry.
stage,
Lordship. Yeah.
Sorry,
Yes, Lordship.
I'm rejecting it. Heard, Mr.
And what's our Lordship?
Miss Wapangla, please, can you give an appearance slip? Appearance slip. And so for the petitioner, also heard Mr. B. Sharma at APP for the state respondent. Stop. This is an application under section 483 of BNSS seeking grant of regular bail to the petitioner, i.e. MD Anash, who has been arrested on 28/10. 2023 in connection with GR case number 321/2023 in connection of Dilai Police Station case number 60 of 2023 arising out of GR case number 321/2023 Taragot Diliba under section 21C of the NDPS Act arising out of so and so. Stop. The brief facts of the case is that the police that the sub-inspector
Yes, Lordship.
complained that the sub-inspector of the Dilai Police Station, Karbi Anglong, lodged a FIR on 28/10/2023 alleging inter alia that at about 10:30 p.m. upon receiving an information from IC Lahorijan PP Police Station Dilai regarding detention of one white color XUV 300 bearing registration number AS26E2081 coming from Manipur, suspected to be carrying drugs, arrested the petitioner in connection with the aforesaid case. It is alleged, and it is the further case of the prosecution, that a total 50 numbers of soap boxes containing packets of brown color suspected to be heroin were recovered from the right side of the rear portion of the car. Collectively, 50 numbers of soap boxes, 11 were hidden inside the AC and music system slot, and 39 numbers of soap boxes were recovered from the right side of the rear portion of the car, collectively weighing 637.28 grams from the which was driven by the petitioner. Accordingly, the FIR was registered. Mr. So and so, learned counsel for the petitioner, submits that your first submission was?
Lordship, there is an undue delay.
No, that was the second. What
Yes,
was the
Lordship.
first?
Conscious
Huh?
possession, Lordship.
Yeah, submits that the petitioner was the driver of the vehicle from which the contraband articles have been seized and hence was not aware of the said articles which were hidden in the car owned by the owner of the vehicle. Stop. He further submits that though the trial has commenced, however, no evidence is yet taken.
3 witnesses are yet.
However, only 3 witnesses have been examined,
Lordship.
and the petitioner is languishing in the jail since last almost 2 years.
Lordship. 6 have been examined. 3 are yet to be examined. Lordship.
6 have been examined. Huh?
3 are yet to be examined.
He further submits that the mandatory procedures as contained under section 41 and 42 of the NDPS Act has also not been complied in the present case. He accordingly submits that the petitioner is liable to be entitled for release on bail. Stop. For contra, Mr. So-and-so Sharma, learned APP for the state respondent, submits that the trial is almost going to come to an end, in as much as out of the 9 prosecution witnesses, 6 has already been examined, and the next date fixed is 5/5/2025. Correct. He further submits that the prosecution witnesses so far examines clearly implicates the petitioner for the alleged offense. He further submits that from the materials available in the scanned copies of the case records of the case, it is evident that there are materials available to reasonably believe that the petitioner is guilty of the offense alleged. Stop. He accordingly prays that the bail ought not to be given. Heard, perused, also seen the case, scanned copy of so-and-so. It appears that the contraband articles have been it appears that the police personnel, upon receiving information as regards the alleged commission of the offense, proceeded to the location from where they apprehended the petitioner and recovered the contraband articles which were kept hidden in the car he was driving. Stop. It further appears that the trial is going on, wherein out of the 9 prosecution witnesses, 6 prosecution witnesses has already been examined. It further appears from the scanned copy of the case records placed before this court that the 6 prosecution witnesses who has been examined so far has clearly implicated the petitioner for the alleged offense. It further appears that the huge quantities of contraband articles of heroin, na?
Yes, Lord.
Quantity is how much?
680.
Mr. Sharma, you can tell the quantity. Just
637.28.
637
It
point
comes
637.28
28. Yes,
grams or kg.
grams lots.
Grams of heroin have been procured from the possession of the petitioner, which was being transported from Manipur to Assam.
From Manipur side lots. He was
From
coming
Manipur. Stop. In the present case, the offense being the provision of NDPS Act, apt to refer to the principles laid down by the apex court in the case of Union of India through narcotic control Curio Lucknow versus MD Nawaz Khan in criminal appeal number 1043/2021. Paragraph numbers 18, 19, and 20 of the aforesaid judgment is reproduced hereunder for ready reference, quote unquote. Reading of the above, apparent that the test which this court is required to apply while granting bail under Section 37 of the NDPS Act is to see whether there are reasonable grounds to believe that the petitioner has not committed an offense and an offense under the Act, and whether he is likely to commit any offense while on bail. Undoubtedly, next paragraph, undoubtedly, given the seriousness of offense punishable under the NDPS Act, stringent parameters for grant of bail under the NDPS Act have been prescribed in order to curb the menace of drug trafficking in the country. In the present case, it is pertinent to note that the contraband articles have been seized from the driver of the vehicle.
Sole occupant lots.
Huh?
Was the sole occupant.
From the driver, from the vehicle which was driven by the petitioner and was the sole occupant of the said vehicle. Stop. The argument of Mr. So-and-so learned counsel for the petitioner to the effect that the petitioner was not having conscious possession of the contraband articles which was found from the car, from the vehicle which he was driving, as he was the mere driver, cannot be accepted at this stage. Section 8 of the NDPS Act to 35, 36, 37, 30 and in the present case, the contraband articles having been seized from the possession of the petitioner, the possession is established. Therefore, the burden is shifted to the petitioner to show how the same has been seized from the vehicle which he was driving. Stop. It is further apparent that out of the 9 prosecution witnesses, the 6 prosecution witnesses who has been examined so far has also implicated the petitioner for the alleged offense. apt to refer to para 39, para 40. Therefore, it is established that the petitioner was possessing the seized contraband articles. This brings me to the next argument of the petitioner, that the trial is vitiated for non-compliance of these statutory procedural prescriptions under the relevant provisions of law is also a matter of fact which cannot be looked into at the stage of consideration of bail. That apart, the fact that the petitioner is been languishing in jail for the last almost 2 years cannot be the sole criteria for granting bail in case of in relation to offences under special act like that of NDPS Act. Thus, what is to be looked at this stage? Thus, what cannot be looked at this stage is that the petitioner was caught with the seized contraband articles of large quantity which establish possession at this stage. Hence, it appears that there are materials to indicate that the petitioner is guilty of the offence alleged. Therefore, considering the facts and circumstances of the case and keeping in mind the rigors of Section 35 of the 37 of the NDPS Act, so and so in mind, this court is not inclined to grant bail to the petitioner at this stage. Accordingly, the bail application stands rejected. Sorry.
Liberty, Lordship, very apology, Lordship.
Huh?
May I take a liberty, Lordship?
1 second. Before I give you the liberty, just 1 second. 28 আছিল না? তোমাক মই এইটো দি দিম হা? এইটো তোমাক এতিয়াই লাগে নেকি? Yes. Yes, Mr. Das.
I'm sorry, Lordship. With regard to attendance 17, 18, 19, and 42, Your Lordship, I have already talked with the
You want another date?
Yes, Lordship. 13th of May, Lordship. They have consented on 13th of
Well, but anybody there from?
No, but I have taken consent from Mr. B. Gogoi, Your Lordship. He has informed AG Advocate General also.
13 করে দিব।
13th of May. Much obliged, Lordship.
All right. এক মিনিট রূপক।
May I please?
Just 1 second, Mr. Shekhar. দেখি পেলাম ঘূৰাই দিয়া। তাৰপৰা উলিয়াই ল'বা, তাৰপৰা চাই ল'ব পাৰিম। Yes, Mr. Shekhar.
Regular bail application, Lord.
30 to 31.
I'm appearing in only in 30 item number.
Your Worship, I'm appearing in item number 31.
All right.
Lots of the case relates to the Manipur violence, Lord. The violence that is going on between the Kukis and Metis. My specific case is that the person, he was arrested on 28th of July 2023, my Lord.
Arrested where?
In Manipur, my Lord.
How come it is filed here?
But all the cases have been transferred to CBA, then the jurisdiction has been transferred to Guwahati, my Lord. Then by the Supreme Court, my Lord.
Do you have that judgment?
Already orders been passed, my Lord.
Is that correct? All right. Yes.
My Lord, my specific case is that at the time of arrest, the section 50 and 50A was not complied with, my Lord. And to that effect, that I have specifically mentioned that in para 17,
50
and 50A regarding grounds of arrest, my Lord.
CRPC.
Yes.
50 and 50.
That is
A.
47 and 48 of BNS. my Lord.
It is the new section is 47, right?
47 and 48, my Lord.
BNS.
I stated that in para 17, my Lord, in page 13. And CBI, they have already, IOS filed a reply to that effect. Your Lordship, can you turn to page 143?
Okay, I shall come back in 5 minutes. Mr. Counsel, I'll just take a short break for 5 minutes.
Yes, sure. I don't know. I have not checked.
Yes.
Lordship, can you take up the objection filed by CVA? They will file an objection, my lord. You also can you turn to page
Objection
140
filed by?
CVA.
Yes.
Also, can you turn to page 143, para 7. 2 line at the bottom.
Yes.
What they have said is that with reference to a statement made in paragraph number 16 and 17, the deponent begs to submit that the assertions made therein are incorrect and misleading. It is submitted that during investigation conducted by the local police, role of the accused petitioner surfaced, and accordingly, the local police has arrested him from Nongpok Lorembam Singlak on 27/2023 by preparing proper arrest memo in presence of witness. That is the only statement against that with regard to that.
Whether informed, not informed, nothing said.
Nothing is said. That is the only sentence they have stated in their objection, my lord. As well as knows the view of the Supreme Court on this matter, my lord.
Rehan Kumar,
Yes, my lord.
Praveen Bansal, Prakash
Ravi Prakash, sir. He is entitled to release on bail, my lord.
He has not finished, ma'am.
There is nothing to argue over. They have to satisfy on this point first, my lord.
That is all you are arguing.
Yes, my lord. I'm not going into the merits of the case, my lord.
Where is the FIR?
FIR is at FIR is at page 17, my lord.
17.
17, yes.
Yes.
The FIR was first lodged on Seikul police station. Meril. I have the honor to state that on 4/5/2023 at around 3 p.m., some unknown miscreants suspected to be members of Meitei youth organization Meitei Lepam, Kanglepak Mbaklu, Arambai Tengal, and World Meitei Council, Seal Tribe Demand Committee, numbering about 800 to 1,000 persons, carrying sophisticated weapons like AK rifles, SLR, Insas, and 303 rifles, forcefully entered our village B failed.
The offense is very great.
Yes, Lord. Maybe. It was a mob of more than 1,000 persons, my lord. And one person has been arrested. He is languishing in jail for almost 2 years, my lord.
How many petitioners are there in your case?
Only one petitioner, my lord.
He's in jail since?
Since 27/2023, my lord.
Almost?
Almost 2 years, my lord.
What about in the other case?
Yes, may I please, Your Lordship? In the other case, Your Lordship, the petitioner, he was not arrested. He was in fact called by the superintendent of police. He telephoned him and told him to come to the police station, Cobalt police station, to discuss some certain issues. And when he went there voluntarily, he went there to meet the superintendent of police. And as soon as he reached there, he was placed under arrest without informing anything. Now, the main allegation against him is that he was not involved in any of the offenses. The only thing is that there was a naked parading of 2 ladies.
There was
a naked parading of 2 ladies.
Naked parading.
Yes, Your Lordship. And he was not involved in the issue, in the offense. There was a circulation of that video. And that video was found in his mobile phone. He never shared the video to anyone. He never showed the video to anyone. The only allegation against him is that the video was found in his mobile phone. And only on that allegation, he was placed under arrest. He was placed under arrest on 24th of July, 2023. And since then, his bail has been rejected by the special judge.
Yes.
Special judge of SC court, then by the CBI court. We went to the CBI court, Kamrup also. There also his bail was rejected. We filed a bail application before the High Court of Manipur twice, and that was rejected on the ground that they don't have the jurisdiction. We have to approach the Honorable High Court at Guwahati. Finally, Your Worship, the Honorable Supreme Court passed the order that we have to, all the cases have been transferred to Guwahati, so Assam, so you should approach the appropriate bench.
Do
Your
you
Worship,
have a
that,
copy of that order?
Your Worship, I have the copy, all the, that order, Your Worship, I have not annexed, Your Worship. I have it with me, Your Worship, that I can produce, Your Worship, and that I can produce. The Honorable Supreme Court has passed that order that all the
In your case also, they have filed an affidavit in opposition.
Yes, Your Lordship, they have filed the affidavit in objection.
Which paragraph they mentions that which paragraph of the affidavit indicates that nothing was communicated to you?
Your Lordship, they have not mentioned anything, Your Lordship. They have just stated that charge sheet have been filed.
No, because why I'm asking you this, because when the accused or the arrestee
Yes, Lord.
alleges that the ground of arrest is not communicated to him, thereafter the owner shifts to the investigating officer, the arrested person, right? Now
Yes,
it
sir.
is for the arrested person to show that this was done. Now, in the first case, from the affidavit itself, it is clear that they could not discharge this burden. Now, what about your case? Have they said anything?
Your Lordship, in my case, Your Lordship, at para number 7 of
Because
my bail application.
I believe that in both the cases, this is the primary ground which is also pleaded in the bail applications, right?
Yes, Your Lordship.
Am I correct, Mr.
Yes,
Shekhar?
Lord.
I don't know about their case, but I have pleaded.
You have pleaded. That's
Yes,
what
sir.
I'm saying. You have pleaded that,
Yes, sir.
right? And you
Your
have
Lordship.
also pleaded it.
Yes, Your Lordship, at para number 7 of my bail application, page number 4.
So what is the reply to para 7?
Your Lordship, para number
Page
7.
5, para 5. Let's read para 5 of page 138.
Your Lordship, I am allowed to read, Your Lordship.
Please read.
That with reference to the statement made in paragraphs number 5, 6, 7, and 8, the deponent begs to state the initial investigation of the case was conducted by the Manipur police, and later the case was transferred to CBI. During investigation conducted by local police, it has surfaced that accused person Namanapong Kiran Meitei, the present accused, received the alleged video clip from one of the accused, namely Pukrangbam Suranjoy Meitei, accused 5. Subsequently, accused petition shared the alleged video clip with others, resulting in the video's eventual viral spread on social media platforms. During investigation, accused person was arrested by the local police on July 24, 2023 by preparing proper arrest memo in presence of witnesses. Thereafter, the investigation of the case was taken over by the CBI. The investigation conducted by CBI established the accused person was part of mob and involved in heinous crimes with physical assault, rape, gang rape of women victims, and murder of 2 victims. During photo identification parade conducted before the Judicial Magistrate First Class, accused person Namarapam Kiran Mitei, accused number 6, was identified by victim 1 and victim 2 as he was in the mob involved in naked parading, sexual and physical assault of the victims, and murder of father, brother of one of the victims. Accordingly, charge sheet was filed against the accused person along with
Allegations, the gravity is.
Maybe it's a allegation only.
You're right. You're right.
So there was a mob of around
You see,
1,000
the
persons.
problem is that this court is now helpless.
Yes, my lord.
We have to balance. Now, how can one ignore the constitutional rights of the arrestee? That is where the problem comes.
Yes,
And at the
sir.
same time, when you read the allegations,
Allegations may be serious, my lord.
the conscience
saying
and the mind of the judge is also there, right? It becomes
May I-
very difficult.
But
May I
there are
please
mob
follow?
of 1,000 persons,
Because
my lord, who has done that. That is
prima
the issue.
facie, this court knows that perhaps this court will have no option now. But at the same time, yes,
Yes, sir. It may be the seriousness of the offense is yes is quite grave, Your Lordship. But the very fact is that one we have to look into the fact that when the accused is released on bail, Your Lordship, whether he has any ground for absconding, whether he is there reasonable ground for tampering the witness evidence or inciting the witnesses, Your Lordship. These 3 grounds, Your Lordship. In my present case, Your Lordship, the only evidence against the accused person, the present
is that you have shared the video. That you
Yes.
received the video clip from one of the named accused person
Yes.
and you have shared it. correct?
That
This
that
is the
again-
allegation against you?
Yes, Your Lordship. That is the only allegation. But the thing is that the sharing of the video, they have said on the social media platform. However, during the relevant time, Your Lordship, the internet, broadband and mobile data has been suspended by the Home Department of Manipur. I have annexed all the documents, Your Lordship. It is there.
Your
There-
case is slightly different, but
Yes, Your Lordship. It is slightly different because my
then
allegation.
Mr. Shekhar's.
Yes, Your
Mr.
Lordship.
Shekhar's case, it appears there is a direct involvement. As per the allegations,
Yes.
as per the allegation. Now,
As per-
what is the position of the trial?
It has not started. They have filed a
Trial has
charge
not
sheet.
started. Charge
They
sheet.
have-
Sources has been
charge sheet has been filed, Your Lordship.
been taken, my lord.
And now
All
I
right,
have been,
sorry, I didn't get your name.
yeah, I am Your Lordship, Juno Rahman, Your Lordship.
Mr. Raman, just one second, let us now, let me also hear the other side for, I'll come back to you both. Yes.
Yes, Your Lord.
Please, your lordship. There is a photo identification and 164 is statement of the accused.
We'll come to all that later, ma'am. First and foremost, you have to show that Article 22(1) has been followed. You have heard the primary contention of both the petitioner seeking bail is that
Yes. Your
the
lordship.
constitutional right which is guaranteed to the petitioner has been totally infringed by the arresting authority. First and foremost, you have to show that whether that is correct or not correct. It is only thereafter that this court will go into the merit of the case, not before that. First and foremost, you satisfy because the objection that you have filed doesn't say so. You don't say.
Accused are arrested by state police. They have given the arrest memo.
That doesn't indicate. Does it indicate?
Subsequently, it is.
Does it
forwarded.
indicate?
Arrest memo, maybe some technical glitches.
You
are
see,
there, right?
Ms.
It has not
Counsel,
been-
you are an officer of the court, right? So when a question is posed to you, answer it in a responsible manner. I understand sometimes the answer may not be in your favor, but nonetheless, you have to answer it, correct?
The arrest memo has been given. To that,
That-
effect, we have already
that-
written in our objection.
That doesn't indicate the grounds of arrest, correct? Except the reference and all. Is it yes or no? Well, put us a scan copy.
CD is, we have brought the CD also today.
Please point it out. Is not here.
Here, it is in the court. Trial court.
Why are you not giving the scan copy? We can call for the scan copy.
Already they have filed their affidavit and they have admitted.
Mr. Shekhar, yes, I understand that. But in the second case also, they're not saying anything, and this affidavit is not filed by the arresting authority. This affidavit is filed by the CBI.
No, by IO. She's the IO.
IO, but was he the person who has arrested the police, the state police? State police. So you see, the state police affidavit is not on record. In order for the court to ascertain, the court will have to have a look at it, correct? Yes or no? That minimum, that much satisfaction has to be generated. Otherwise, there is no difficulty. But yes, how much
Ma'am.
time will it be take? Where is it? The scan copies are before which court?
Before the trial court, special judge CBI.
What itself.
At Guwahati itself.
Right.
So you have it. I think registry will have to get the scan copies. So we can fix this on Friday.
Will be too short. No,
Yes, sir.
short because I
Right.
have come from Ranchi.
Who has to come?
From Ranchi,
Who has to come?
IO.
What does the IO have to do?
Because of the CD and they will have to carry the CD also.
You said it is in the court.
Original papers are there.
So
CD is with IO.
we'll call it from the court, then scan
Only
copy.
the relied upon document and witnesses list are given there. Always remain there with the IO. 15 days time, 15 days time. for that.
As counsel,
that
this
she
court
can
is
come.
not going to give you so much time. Constitutional right of the petitioner is at stake. This court cannot ignore that submission. You cannot be given so
Then
much time.
It can be kept, kept tomorrow.
Tomorrow?
She will cancel her ticket. I'm asking them
Yes.
to cancel the ticket.
Yes, tomorrow. I'm fixing this matter tomorrow.
Yes,
I
Lord.
hope,
Yes,
is
Lord.
she the IO?
He's the DSP. not
Ma'am,
the
I hope you've understood the question of the court. So just point it out from the arrest memo what is available. That's all the court wants to see. All right.
Original is lying there in the special judge CBI.
No, but a
He will bring the
photocopy.
copy of the memo.
Yes, yes. The photocopies will do.
Deeply obliged.
Relist tomorrow, huh? Both. And Mr. Counsel, Mr. Raman and Mr. Shekhar, please give us short note on the facts of both the cases.
Yes.
You know, the
Yes, sir.
relevant dates and just that.
Yes.
Because
Yes,
it'll
I'll
be
provide.
easy then. Please provide it,
sir.
both of you.
Yes, sir. I'll provide it.
Yes,
Wait,
Mr.
wait, wait.
Manan.
This is a 483 application. Here the petitioner was
Item
arrested.
number 33.
33. He was arrested on 2/4/2024, Your Lordship, under section 22/29 of NDPS, Your Lordship. Basically,
I hope you're not arguing the same ground
it's
again.
basically the same ground. Here the fact is that this the recovery was from a train from another person, Nityanand, about 15-16 days prior, from a train in Guwahati. This person is having a pharmacy. These are simplex tablets, capsules. So he has a pharmacy, and his house and pharmacy has been raided. Nothing was recovered. Only on the basis of section 67 statement of the co-accused, he was ultimately arrested on 15-16 days. And the grounds have not been given. I have given the
Grounds not given.
not given. That is at page 69 and 70.
Page
69, 70.
69.
69, Vinay Kumar, and 70 is Rajnikant Kumar. These are the two persons, Your Lordship. This case.
Mr.
Nothing is-
Kayal, is that position correct?
I have to check up the records, Lordship.
No, it is there. You see the records. I'll take it up at 2.
Not come, Lordship.
Records are in. That
It
it is not informed.
I
Because
cannot-
your arrest is prior to
Absolutely,
Bansal.
prior to Probir Prukaisto and prior to Bansal. also.
Bansal.
Bansal, then Probir Prukaisto, and then that-
Arora has clarified that Bansal is prospective.
Aurora will make appropriate, sir, because my lord, how can to me, my lord, I may be wrong, my lord, how can a constitutional provision be
In
prospective?
writing.
Eh.
What has been, you see, what has been clarified in Bansal is that it has to be in writing. You see, the word used is informed, right? Now, generally, the trend, if of course, there are a lot of scope of arguments here, is informed. Now, once you take this ground, then the onus is for them to show whether informed, not informed, right? It can be informed, there can be witnesses who may come and say, no, it was done. That is sufficient earlier. Now in Bansal, for the first time, it has said that no, it has to be in writing. Now, therefore, Arora have said, in Arora, it has been clarified that that is prospective. So any arrest which is going to be made thereafter, in that, if it is not there in writing, it would not vitiate the arrest. Have you followed? But in your case, perhaps this arrest is prior to, that is why I'm saying that writing thing will not come. Now, of course, if the arrest memo and the other thing shows that except reference and all, nothing is given,
Nothing is given.
but it will still be on them to show.
Yes.
Now, they will get a chance to show when you take this ground. That is why I'm asking. Otherwise, from the materials, we'll have to see.
My lord,
Anyway, that is one thing.
absolutely. What
Have
is
you
called-
given that note which you were supposed to give?
Yes.
Have you taken all this? In your note?
This in my note, I have taken all these grounds as well as I have also given the dates. My lord,
And the citations have you given?
citations, I'll give I have.
You said you're going to rely on a number of
Yes,
citations.
my lord, these are the These are coordinate bench as well as Supreme Court, my lord. I don't want to burden your lordship with all these judgments. These are, my lord, 1 year, 6 months and above, my lord, more or less.
So three grounds, one is prolonged incarceration, grounds of arrest not intimated and not recovered from the possession of the
Yes,
petitioner.
arrested on the basis of 67 statement, which is an inadmissible piece of evidence. And each ground in itself is, my lord, in my respectful submission, is sufficient for bailment. My lord, this judgment, your lordship will see, this is Dhiraj Kumar Shukla, paragraph 3. Para 3, my lord, will see. It appears that some of the occupant of the Honda City car, including such and such, have since been released on regular basis. It is true that the quantity recovered from the petitioner is commercial in nature and the provision of section 37 of the Act may ordinarily be attracted. However, in the absence of criminal antecedent and the fact that the petitioner is in custody for last 2.5 hours, we are satisfied that the condition of section 37 of the Act can be dispensed with at this stage, more so when the trial is yet to commence. And
Yes.
this is, and the coordinate bench judgments, my lord, Anil Yadav, 2 years, 5 months, prolonged incarceration, bail granted.
Here it is, 2 years.
2 years, 5 months. Then another is Ranjit Mandal, that is also 2 years, 5 months and 28 days.
2 years,
5 months and 28 days.
20 days.
28, 289 days.
Yes.
Then the next is Pramod Kumar, 1 year, 9 months.
1 year.
9 months.
This is also NDPS.
And all commercial quantity.
Yes. I can find you had appeared in all of these cases.
Yes.
Cases, Lord.
Yes.
There are some judgments where lordship bail has been granted for 5 years also. I'll produce their judgments.
Bail
By
is?
coordinate benches
Bail has?
rejected.
Where is that?
I'll because I have not brought.
Why?
I'll supply lordship. Also.
Why you have not brought it?
I'll, after
You
some
should have
time,
brought it. This matter, this court has been hearing from tomorrow. Today we
but
specially
lordship,
accommodated
these
you and
issues-
have fixed it today.
only they
When matters are fixed for hearing, you
No.
must be armed with all the relevant
No,
case
no,
law.
no,
This
no.
is the basic argument of the Mr. Biswas.
they have relied on Ravi Prakash. I have come to
Correct,
judgments.
but that is the
I'll
basic
I'll
argument.
produce-
If you want to distinguish that, that was the best decision which you can show.
I'll lordship here.
What is this, Mr. Kayal? 1 year?
This is 1 year, 9 months. And I can, my lord, I can give a list of Supreme Court judgment as latest as in the 2025, where 1 year, 6 months, 2.5 years, 1 year, 6 months, 1 year, 7 months, they have been arrested with. And moreover, my lord, in this case, my lord, he has been arrested purely on the basis of a statement recorded under section 67 of the
Co-accused.
Co-accused. And that is an absolutely inadmissible piece of evidence. So the, my lord, the outcome of the trial is quite obvious and looming.
What
large.
was Kasif's case?
Yes, I come to Kasif case. That is it.
Who had given that?
Kasif case was 11. My lord, my lord,
Oh,
my
that
lord,
was a normal.
I'll
yes.
explain. My lord, my response to the Kasif case is this, my lord. My lord, kindly take up the Kasif's case for a while. My lord will see here the High Court has granted bail on 18/5/2023, which your lordship will find at para number 2 of the judgment.
Yes.
The instant appeal arises out of impugned order. Impugned order, the order of granting bail. On 18/5/2023, bail was granted. When was he arrested? My lord will kindly see para number, page 3. If my lord, if I am carrying the copy from live
The
law
bail was granted on 18/5/2023.
by the High Court.
Yes.
And my lord, he was arrested on 7/3/2022.
Oh, almost not even
1 year, 2 months.
1 year, 2 months.
This is number 1 in Kasif's case.
Which paragraph you said?
Your lordship has got the date of bail.
Bail I have got. Arrested?
Arrest your lordship will find at para number para 3 Roman 3. Para 3 Roman 3.
What is the date? 7/3.
Yes, 7/3/2022 he was arrested along with another co-accused.
7/3/2022. 3/22 arrest. Yes.
Now, my lord, your lordship, my lord, a decision is a binding on the issue which it decides, my lord. Now, my lord, what was the issue in Kasif case? Kindly come to para number 2. The issue involved in Kasif,
All right,
Kasif case
all
was.
right. I'm granting the bail, Mr. Kayal.
Lordship, have some judgments of coordinate bench where bail has been granted after,
Bail has been granted after?
and they were rejected, even if the accused are in custody for more than 4 years. Lordship, this is a judgment. So is bail application number 3130.
Please show.
How many judgment, Lordship, I'm giving?
Yes, take down. Heard Mr. B. Biswas, M. Biswas, learned counsel for the petitioner. Also heard Mr. S.E. Kayal, learned
Standing counsel NCB law.
standing counsel, NCB. Stop. This is an application under section 483 of the BNSS 2023 seeking grant of bail to the accused petitioner, i.e. Aminur Islam Elis Sukur Elis Shakur Mian, who has been arrested on 16/6/2020. Huh?
This date has been wrongly tagged.
16/6/2021 in connection with NDPS case number 108/2020 corresponding to NCB crime number 10/2020 registered under section 20B(2)(c) and 29 of the NDPS Act 1985. Pending before the learned additional session judge number 2, Kamrup M. Stop. The facts of the case is that facts of the prosecution case is that on 15/6/2020 at about 4 p.m. the concerned junior intelligence officer of NCB Guwahati, upon receiving an information from a reliable source that 3 petitioners, petitioner's name is not here, right?
No.
3 persons, namely MD Kari, Kuntunde and Ravindra Ray, will be carrying a huge quantity of ganja by concealing the same inside the cabin of a container truck bearing registration number capital CG08L-3066, the NCB team, after reaching the said location, apprehended the said truck, and while searching the said vehicle, found 36 packets of ganja, which was kept concealed in the cavity made behind the driving seat of the said vehicle, weighing approximately 484.300 kg. Accordingly, a case was registered and the three persons named above were arrested. Thereafter, the petitioner was also arrested on 16/6/2020.
Three, my lord, three.
Huh?
16-3.
16/3. Your the dates are all missed. Your paragraph 4, 16/6. You have to be careful.
2021. That's the date.
That's correct, right?
Yes.
16/3/2020.
21.
So, have a look at page 4.
I understand.
Huh?
I understand. My apologies.
Lordship, correct date has been given.
I'll go to the note, but I'm dictating the facts. One has to also see
My
the.
apologies. my lord. No.
No, the problem, Mr. Biswas, is especially in bail matters
Absolutely.
because stakes are high, and then when we give orders, this court has to see the facts as pleaded. One mistake, then even if in a case when this court grants bail, you will not be able to execute that order because
Absolutely.
of that mistake. Isn't it, Mr. Kayal?
Absolutely.
So the responsibility is on the petitioner counsel.
Absolutely.
What is this? 16/3/21.
21.
Huh? Accordingly, the instant bail application has been filed. Mr. So-and-so, learned counsel for the petitioner submits that the petitioner has been languishing in custody since last 4 years, 1 month and 14 days, within bracket approximately 1506 days. He further submits that charge was framed on 31/7/2023 against the petitioner and the other co-accused, and the trial having commenced, out of 10 prosecution witnesses, only 5 has been examined till date. He further submits that the materials available on record would indicate that no contraband articles have been recovered from the possession of the petitioner, but merely on the statement of the co-accused, the petitioner has been dragged into the alleged and has been arrested in connection with the instant case. So, he further submits that the grounds of arrest, which is the constitutional and fundamental right of the petitioner to be informed under the Constitution of India, has not been informed to the petitioner by the arresting authority at the time of his arrest. He further submits, you are being called and then you are kept, you said.
Yeah, I am arrested on the basis of the statement made by Ravinder Ray, that the other co-accused.
That I have said. Okay. He accordingly submits that on this score alone, the petitioner is liable to be released forthwith. He further submits that there being a prolonged incarceration no, don't say that. He further submits that the petitioner being in custody for almost 4 years, 1 month and 14 days, his fundamental and constitutional rights under Article 21 of the Constitution of India is also infringed. And accordingly, on that account alone, he is liable to be rejected. He is liable to be released on bail. Stop. For contra, Mr. Esikayal, just before that, you say, in support of the aforesaid submissions, he relies upon the decisions of the, he relies upon the following decisions. Number 1, Ravi Prakash versus State of Odisha, reported in 2023 SSC Online Supreme Court 1109. Dheeraj Kumar Shukla versus State of Uttar Pradesh in SL. What is the citation?
It has not been reported. The case.
No, the number.
Yes, case number would be, my lord, special SLP within bracket criminal number 6690.
SLP within bracket criminal number S6698 of 2022.
Yeah.
Number 3, Anil Yadav versus Union of India in bail application 434 of 2024. Then thereafter, before that, on top you say following decisions of the apex court. Okay. He further submits that by applying the aforesaid principles enumerated by the apex court, to the effect that in the event there is prolonged incarceration which militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. How did I start? Various coordinate bench of this court has granted bail to persons who have been languishing in jail for a long span of time, which are as follows. Okay, there you put these cases. Anil Yadav versus Union of India in bail application 434/2024. That was given by you, right? Yes. Ranjit Mandal versus Union of India in bail application 3855 of 2024. Pramod Kumar versus Union of India in bail application 434 of 2025. Per contra, Mr. Esikayal, Leonard Standing Counsel, and NCB, by vehemently opposing the prayer of bail, submits that a large quantity of ganja was seized from the conscious possession of the petitioner. Conscious possession.
Or from some other person, he was arrested subsequently.
Correct. But so that is why conscious possession. No, you're not saying that. All right. Was recovered from the other co-accused person. However, it has come out during the investigation that it is the petitioner who is the main supplier of the contraband articles seized in the matter. Correct? Stop. He further submits that the Colin Daily reports available in the case records clearly reveals that the petitioner was in constant touch with the co-accused persons. He further submits that as of now, 5 out of 10 witnesses has been examined during trial. And so far as the trial of the case is concerned, it is at the evidence stage, and the next date of evidence is fixed on 8/5/2025. He further submits that all the material witnesses in the instant case has been examined, and the remaining witness consists of 2 independent witnesses and 3 eyewitnesses and 2 additional witnesses as nodal officer. He further submits that so far as the independent witness is concerned, steps were regularly taken, but the witness is not turning up, and regarding the nodal officer of Airtel and Vodafone company is concerned, steps has been taken in respect of these witnesses, and the next date of evidence is 8/5/2025. He further submits that as regards the 3 witnesses cited as eyewitness, is not essential in the case. In view of the aforesaid, he further submits that the trial of the case is at the end stage and only the evidence of nodal officers is remained. Hence, the prayer of bail is liable to be rejected. He further submits that the decision of the apex court, as relied by the British Learned Counsel appearing for the petitioner, are in the context of those cases and cannot be applied in the facts of the instant case, inasmuch as the trial is likely to be concluded within a short period of time. Correct? Stop. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of Narcotics Control Bureau versus Kashif, reported in 2024 SSC Online SC 3848. He further submits that various coordinate benches of this court has also where is it coming from? What is on? Mute corridor. Yes. Has also rejected bail application of accused persons who have been languishing in jail for more than 5 years. In support of the aforesaid submission, he relies upon the decision of a coordinate bench of this court in the case of Mahendra Singh versus Union of India in bail application 3130 of 2024. It appears that considered the case laws. It appears that the petitioner has been arrested on the basis of a statement made by the co-accused. Stop. It further appears that the arrest memo, you have flagged it.
I have not gone through that, whether I can assist your lordship, people.
Yes, it further appears that the trial has commenced, and out of 9 witnesses, 10 witnesses, only 5 witnesses have been examined. It further appears that the petitioner has been in custody for more than 4 years, 4 years, 1 month, and 14 days. Stop. Apt to refer to the decision of the apex court in the case of Rabi Prakash Supra, wherein the apex court, in the context of Section 37 of the NDPS Act, has held that in a given situation where there is prolonged incarceration, the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. Paragraph 4 of the aforesaid judgment is reproduced hereunder for ready reference, quote unquote. Apt also to refer to the decision of the apex court in the case of Dheeraj Kumar Supra, wherein the apex court has held that even if the recovered quantity of contraband article is commercial in nature and the provisions of Section 37 of the Act may ordinarily be attracted, in a given situation when the petitioner is in custody for the last 2 years, 2.5 years, the conditions of Section 37 of the Act can be dispensed with Stop. Paragraph 3 of the aforesaid judgment is quoted herein, which is reproduced and quoted. It is apparent from the materials available in the record that it is only 5 witnesses who have been examined out of the 10 witnesses so far. It is further apparent that there is nothing available on record to indicate criminal antecedent against the petitioner. Though Mr. S.C. Kayal, learned Steny Counsel, NCB, has tried to convince this court that the trial is likely to conclude soon. However, considering the snail speed of the trial in which it has been going on, this court is afraid that the said contention of the learned so-and-so cannot be accepted. the decision of the apex court as referred above is squarely covers the case of the applicant, of the petitioner, inasmuch the petitioner has been languishing for more than so and so, you put that, in jail, and the trial is unlikely to conclude soon, and there is nothing adverse as regards the criminal antecedent of the petitioner available on record. Therefore, I have no hesitation to held that the conditional liberty which is provided to the petitioner under the Constitution of India must override the statutory embargo created under Section 37 of the NDPS Act. Stop. That apart, the materials available on record does not indicate, correct, does not indicate that the grounds of arrest has been informed to the petitioner at the time of his arrest. It is a settled principle of law that when the basic constitutional and fundamental right of the arrestee of being informed the grounds of arrest by the arresting authority is not complied, comma, the courts has no option but to release such arrested person. Stop. Thus, on this score, in the present case, as stated above, the grounds of arrest having not been intimated to the petitioner at the time of his arrest, there is the Article 22(1) of the Constitution of India is totally infringed. Hence, the arrest is vitiated, and on this score also and alone, the petitioner is liable to be, is entitled to be released forthwith. For the reasons stated above, but without expressing any views on the merits of the case, the petitioner is directed to be released on bail subject to the following conditions. You give all these conditions, NDPS conditions, the trial every day to on each date and all that. Satisfaction of
learned additional
Additional Session Judge number 2, Kamrup Metro at Guwahati.
Got it.
Additional
Mr.
Session
Biswas, please ask your junior to just put it in a piece of paper. And bail bond 50. Bail bond of
1 crore, 1 lakh lots.
Huh?
1 lakh.
Mr. Kaya,
1 lakh lots. This in
huge quantity.
in case of NDPS cases, normally 1 lakh has been given.
1 lakh of 2 sureties, one government,
He is from Tripura state.
one local, with one local surety and 1 lakh, allowed.
I'm deeply obliged.
Kita yet DD Iman Asila item number 40. All right. Yes.
Please, Your Lordship. It's a mere check bounce case, Lordship. 138 case.
Case diary was called.
The scan copy was records were there, basically state we had a formal party otherwise in a case, but he in this case earlier bailable were subsequently NBW and thereafter was arrested. Otherwise, that case is still going on and arrested on 6/4/25, around 23 days in jail. So, but appear before the court below and otherwise, NIA case, malad, normally, but he has since long, malad, bailable warrant on 18/3/25.
Non-bailable warrant.
Earlier NBW, bailable warrant in January, 6/1/25. Subsequently, NBW
And then BWA.
NBW was issued.
Where are those dates?
He has issued Annexure 2, page 10.
You appear.
Yes, Lordship. I'm behind the bar, Lordship.
He is behind the bar now.
You have been already arrested.
Yes.
Because of the NBW.
Rightly so. Rightly so. Why did you stop appearing?
Lordship, actually, since it is a monetary dispute, Lordship,
So,
I went to my native place for arranging some to resolve this matter, Lordship.
Last order rejecting the bail, page 15, Annexure 6. Court below has rejected the bail.
Yes, 16. Yes, 16.
because of your absence, the matter was not being able to proceed. You have not challenged this case.
Malad, otherwise, NBW order is there and
Yeah, but this is because this is a bail application.
bail application because it is rejected, now they have come from bail. So they have come for Malad,
What's the-
583 also.
Correct. Is that not correct, Mr. Parag sir? Ideally, that should have been done.
Earlier 482, now
But this is,
528. So
why should this court grant you bail?
On the basis of the rejection order.
I'm saying if you, then you come before the appropriate provision of law. Then you want to
Only-
withdraw and file.
Lordship, already since long time I'm
No,
behind.
that is not,
now it is 520, earlier 482,
yes.
528 of BNSS.
Why should this court grant you bail? You will not follow the conditions. You will remain absent for a long time. You will not use your mobile phones to
Yeah.
contact your lawyers. And then when the bail is, when NBWAs are issued and it is
That
not
order will remain, my lord, if.
correct, that's what I'm saying.
Well, my
That-
lord,
that-
that
You
order
want
will
me to dismiss it on merit? I'm going to dismiss it on merit. It's not maintainable, this bail application.
Lordship,
I'm giving you the option. You want to withdraw and file it, you file it. Otherwise,
already long weeks, Lordship,
take instruction. I'm not convinced. Tomorrow,
maybe taken today.
all right. Next.
May I please, your Lordship? Last 47 days I'm behind the bar, Lordship. Lordship,
Is he available?
Yes, yesterday's case, my lord, Mukhan, I am being the CD, my lord, from this case.
I have forgotten which one.
My lord. It has come yesterday, my lord.
Mr. Parag,
Otherwise-
it is not
otherwise-
possible for the court to
no.
remember.
Otherwise, the victim girl statement, as per the statement of the victim girl, there are love relation between the boy and the girl, accusing the girl. Since last 3 years, that relation was break out. Now,
Since 3 years,
there is
relationship,
no relation, breakdown of the relation, but that boy, mentally and physically, give pressure to have some relation with that girl. And that night around 11:30, he came to the house of the girl and forced her to go with him. Even then, at that point, her mother also came, and he assaulted the mother of the girl also. In that moment, hearing the hue and cry, neighboring people came, and he was caught and handed over to police. Now, 47 days. Otherwise, only that some scuffle with the girl and assaulted the mother also.
allegations are serious.
He forced to
Victim statement is there.
victim, her mother's statement also. Yeah, only 47 days.
Length of delay.
Only on that part,
Tomorrow, my elder brother's ceremony is going to be held, Lordship.
That cannot be a ground.
Lordship.
That cannot be a ground.
10th of detention considering, Lordship.
But forcefully
You would have thought
cannot-
about all that.
when the girl refused this relationship, then he forcefully want to make that relationship.
This is item.
Item 45.
45.
You are Mr. Kutub Ali.
Yes, Ali, Lordship.
Heard MDS Ali, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned APP for the state respondent. This is an application under section 483 of the BNSS 2023, seeking grant of bail to the petitioner I. Anmani Das, who was arrested on 13/3/2025 in connection with Dispur PS case number 228 of 2025, registered under section 3293/82/62/1091/76 of BNS 2023. The brief facts of the prosecution case as unfolded is as under paragraph 2, A to A. Thereafter, the petitioner was arrested on 13/3/2025 and forwarded to and since then he is behind the bars. So petitioner's statement is already taken. Mr. So-and-so, learned counsel for the petitioner, submits that there was a relationship of love between the daughter of the informant and the petitioner, and there was an argument between the informant and the petitioner over phone regarding the said affair, and the informant had scolded the petitioner. Stop. He further submits that on the date of occurrence, when he went to the nearby area of the informant's house, the informant had informed the police and had lodged the instant FIR against him. He accordingly submits that the allegations are totally false, fabricated, and concocted only to harass the petitioner. He further submits that the informant has falsely implicated the that's all right, it's already come. He accordingly submits that the bail that the petitioner be released on bail. Per contra, Mr. K.K. Parashar, learned APP for the state respondent submits that the statements of the victim and the informant has already been recorded under nowadays it is section
181.
recorded under section 181
180, sorry.
180 of BNSS by the investigating officer and other witnesses
Other two witnesses,
and also statements of the other witnesses have also been examined, examined by the investigating officer. What about the petitioner?
Not his statement also there. He stated that.
All right, one second. He further submits that the petitioner's statement has also been recorded by the investigating officer. It further appears, heard and all that. And he further submits that from the materials available on record, it appears that there was a fight. There was a scuffle between the petitioner and the informant. Between the victim girl.
When the mother came to save.
And when the mother had come to save the victim girl, she got injured.
She was also assaulted.
She was also attacked. Stop. Heard, perused. It appears from the materials available on record that there was a love relationship between the petitioner and the victim girl. And after you said there was a breakup. After the said relationship had fallen apart, the petitioner still was forcing the victim girl to
have relation with him.
To continue to have relationship with him. It appears that thereafter, on the date of occurrence, there was a scuffle between the petitioner and the victim girl, and when the informant had gone to save the victim girl, she was also attacked. It further appears that the investigation has substantially progressed. It further appears that the statements of the witnesses, including the victim girl and the informant, has already been recorded. It further appears that the petitioner has been languishing in in the custody since last 47 days. In view of the aforesaid, it appears that considering the length of detention and that the statements of the material witnesses having already been recorded, and that nothing adverse as regards the antecedent of the petitioner is available in the case diary, this court is of the considered opinion that further detention of the petitioner is not justified. It further appears that there is no criminal antecedent of the case diary. Accordingly, will provided satisfaction of
CGM Kamrup Metro.
arresting authority.
No, CGM Kamrup Metro.
CGM Kamrup Metro and bond. Disposed of.
Highly obliged.
34. POXO.
Please, your lordship, 482 application and in
Yes,
connection.
what about scan copy
Has been received, Lordship.
received?
Yes, Lordship.
You're appearing. Yes.
My lord, accused person is a
Now
diabetic.
you want to say something?
I have a preliminary objection regarding the maintainability of the application, Lordship.
Why?
Lordship, because it is registered under 72, that is gang rape. Lordship will kindly come to the provisions of 482, Lordship, of BNSS. This is anticipatory bail, Lordship, filed under BNSS.
There is a bar.
Yes,
Section
482
PNS.
of BNSS. Subsection 4, Lordship.
482.
Yes, 482, subsection 4.
Section
Subsection 4. 482, subsection 4, Lordship.
under
Nothing,
section 65
and
and
subsection 2
of
section
70.
70.
Now
Is-
here 2 of 70.
Yes.
Yes, then there is a bar. How is this maintainable? Huh?
Allowed to file another.
You may be allowed to file what?
How to withdraw this.
You want to withdraw? You can withdraw. What liberty? How can you file another anticipatory bail application? If tomorrow you are arrested, of course you can file a regular bail application. Your name?
G. Kakoti Das. GT Kakoti.
Heard MSG Kakoti Das, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned APP. Sorry, B. Sharma, Learned APP for the state, and MS MK Brown, Learned Amicus Curie, representing the respondent number 2, stroke informant. It appears that the instant anticipatory bail application arises out of an offense under subsection 2 of section 70 of the BNS 2023. It appears that under section 482 of the BNSS 2023, an anticipatory bail application does not lie in cases where the arrest of the person involves acquisition of having committed an offense under section 2 of section 70 of BNS 2023, amongst other. That being so, the instant anticipatory bail application is not maintainable. Upon being at this stage, MS so-and-so seeks to withdraw the instant anticipatory bail application. Prayer is allowed. The instant anticipatory bail application accordingly stands dismissed on being withdrawn. It is needless to be clarified that the petitioner, if arrested, is at liberty. Do you want this clarification or not? Because you already you don't want it. Okay. I think it is not necessary. Huh? Disposed of. Box. Okay, it's got off course and a video.
Yeah, please, Your Lordship.
Yes, 35. POXO.
FIR is on page 8, my lordship.
Case diary, Mr. Parashar.
It is there. Typed copy of the FIR is on page 8, my lord.
Page
8, my lord.
Page 8.
May I read, my lordship?
1 second, let me reach. Yes.
Is respectfully stated that accused number 1 nearly 2 years ago
Lived my minor daughter Aklima Sultana, date of birth 16/3/2007.
NBW, Lordship. In this case, bail application has been filed, Lordship, preferred, Lordship, and then court granted the bail, Lordship. So, see the bar for
In this
preferring
case,
the bail application. So in this case, it is not written.
then, so why are you showing this
In
case?
case of FIR, my lord, bail, my lord, now regarding this NBW order, that order will remain, my lord.
That is why I am telling.
To
Mr.
set aside that-
Counsel, you see, that order of the court will stand unless and until it is interfered, right? Now, how can I interfere in a bail application? Do I have the power to interfere that order? Even if you file it by tomorrow and you come, I can do something. But unless and until you file an appropriate application, how can this court help you? If I grant today, if I grant bail, then what happens to that order?
That order will remain.
Bar Lordship with that person.
No. What is this, Mr. Counsel? I appreciate your hard work, but you see, you cannot forcefully get an order from the court, right? You have to be entitled to get an order. Have you understood the issue or not? You have come in a bail application for securing bail. In the facts of a case where the person is inside because of an order passed for non-appearance, where NBWA was issued.
But yes, Lordship,
That order is not interfered. If you would have come before the inherent powers of this court, then this court could have exercised the inherent jurisdiction.
But if we prefer the criminal petition, it will take so much time.
No, you see, you should have thought about it. You are a lawyer. You are presumed to know the law. You should have thought about it.
For Malad, his benefit, Malad, if it is closed today, Malad, that record will remain, Malad. LCR has come. And if he file an
That's why I said, if he files tomorrow,
that can be tagged, Malad. That it will help you.
Even if you file tomorrow,
because record is there.
And I'm going to mention for Lordship that may be allowed, Lordship, for
you
make a mention for that. You have to first file, Mr. Counsel. Please be mindful that you are on legs before a constitutional court. You must be mindful of what you submit. You cannot take the courts.
So better withdraw it.
Don't convert the courtrooms into some living room. There are certain tickets which you have to maintain. Anyway, so then should I keep this and fix this matter till tomorrow? Let him file that.
A day after tomorrow, Malad.
I'll keep this. I'll not do anything with this. Tomorrow we can close this one and pass appropriate order in the other one then.
Tomorrow you can email.
Tomorrow, day after tomorrow.
Let me fix day after tomorrow. If tomorrow he'll file, then it will come.
List.
Make a mention.
You make a mention if you file, otherwise it will not come. But then that application will not be listed before this court. Because that
if it is closed also today, Malad, then also he can make a mention at the motion stage, Malad.
I think he can do that before the appropriate bench. I think that would be appropriate.
Record will be called for.
Yes,
This record will be called for.
It appears that the instant bail application, the first, Mr. Ray, heard Mr. N. Ray, Learned Counsel for the petitioner, and Mr. K.K. Parashar, Learned APP for the state of Assam. It appears that the instant bail application is filed for securing, for releasing the petitioner on bail in connection with complaint case number 3961/2021 NI Act as per order dated 7/4/2025. who was arrested? Who was arrested in terms of the order dated 7/4/2025? Who was arrested on, huh?
Arrested on 6/4, my lord.
No, who was arrested in terms of the order dated?
Orders are there, Lordship.
Which order as per?
7/4 order is rejecting his bail, my
Rejecting
lord.
order. Prior to
7/4
that,
order is rejecting his bail. And the NBW order is, my lord,
What is this prayer, Mr. Counsel? What do you mean by grant of bail in connection with complaint case, comma, in the order dated so and so? What do you mean by that? Who was arrested on 6/4/2025 in terms of the NBWA
order dated 10 to
order
25.
dated 10
10 to 25.
2
10 to 25.
10/2/2025. Stop. It further appears that the learned jurisdictional magistrate court by order dated 7/4/2025 rejected the bail application, rejected the prayer of bail. Stop. It appears that no application challenging the order dated 10/2/2025 has been preferred, has been filed. That being so, any order, any relief granted in this bail application would amount to that, upon being confronted with the aforesaid position, Mr. So-and-so Ray, learned counsel for the petitioner, seeks to withdraw the instant bail application with a liberty to file appropriate application. Okay? Prayer is allowed. Prayer is allowed. The so-and-so stands dismissed on being withdrawn with liberty.
no observation may be given regarding retention of LC.
It will remain.
Mr. Parasha's words are sufficient.
Photocopy will remain, my lord.
You keep it, Mr. Parasha. Otherwise, it will be difficult if I give that order and you don't file.
No, my lord. This photocopy of LCR actually remains with them, my lord.
It is needless to be clarified that the photocopy of the scan copy of the trial court records shall be retained in connection, shall be retained in the court records.
Of this case, man.
It shall be retained in the records of this case. And in the event an appropriate application is being filed before the court, the same can be tied along, right? The same can be tied. Do I need to give that? Not needed.
necessary, my lord. He has
Hey, but
make a mention.
yes. To me.
Otherwise, his complete lordship can reserve it for judgment, your lordship.
This is that
This is
that interpretation.
of domestic affidavit.
All right. I think written arguments have been also given. Siddharth, Mr. Borwa was appeared, no? Huh?
I'm submitted Burwa, as Burwa.
As Borwa had appeared.
X and Y, your lordship, or no?
Well, you're not going to make any further. Last time, I think on your prayer,
Lordship, on the last occasion, Mr. Bora was not present. Lordship had fixed it for that reason.
is it?
Otherwise, matter was to be closed for judgment, your lordship.
I thought Borwa's part was over.
But asked for written submission and lordship to be submitted by 10/4 We submitted it on 11/4, your lordship.
What about for the respondent side? They have also given a written argument.
Yes, filed, your lordship.
Today is Tuesday, right? The arguments have been concluded and written submissions filed by both parties are on record. List on Thursday, so and so, to make an endeavor to pronounce the to deliver the judgment in open court. All right. This CAV makes it very difficult. It's let me have a look at it and I'll try. I remember the entire, I think, argument was what is to be read. মনত পেলাই দিব, huh? This is the third matter. Yes.
Lordship, last Thursday, my lord, when instructed, my lord, directed to give him, my lord, synopsis of my argument, my lord, points, my lord, in which I was stressing, my lord.
I have forgotten everything. After taking up so many bail applications and anticipatory bail applications and disposing
My lord.
couple of them, Mr. Das, it is very difficult.
That's what I was discussing with Kyle. There has to be some files.
It's very difficult, and especially when it's a different bench, because you see, suddenly to reconnect from the criminal bench and to get back to the
This matter, my lord, where advertisement was there for one. They
oh
appointed
they appointed two.
and one they are saying that respondent for 4 is not
Eligible.
qualified, not eligible. And for two.
Correct.
He also goes because it is beyond.
You were
the
for
advert-
4. You were for 4.
Five.
5 and 4 was
4 was they're questioning his degree, my lord. Not a bachelor in engineering.
but even if he goes, 5 is there. For some reason, if 4
He
goes,
will, because he says, my lord, it is not equivalent. So whatever degree.
the
you have,
degree.
Degree is not equivalent to B. The advertisement says B. Is not equivalent to B. Therefore, he goes. That's what he says.
And as
my
far as you
submission
are
is-
concerned, he
I'm
says,
concerned, even if it is, my lord, beyond the advertised post, now because of the, said why I have been appointed, and now it is 7.5 years. Court says, my lord, in the is more than 6 years, even if there is some difficulty was there, the process of selection, after 6 years, at least in Supreme Court, last time, because now it is more than, it is almost.
any written arguments have been given.
Yes, I will depend upon only one Supreme Court judgment, which says, my lord, even if it is illegal, my lord, you cannot touch him, you cannot remove him now. They should have got a stay order in this case.
Mr. J. Chutia you had given one judgment, Madan Lal. Which is the decision that Mr. Das you are relying? Have you
I'm just
given?
giving a judgment, my lord.
Have you given, Mr. Das?
I'm giving it, my lord. Your lordship will kindly see the last paragraph only, 54.
No,
and
which one? Which one?
I'm giving. This one, my notice which 2 or 3 pages, my lord.
Made by?
Editor guidance. Last paragraph will do. The case where, I mean, district judges were selected, there was violation of, yes, mine,
The other one?
even on the matter.
Yes. So this
Where
is the
district-
case.
Yes. Last paragraph, your lordship will kindly see. Conclusion points, paragraph 55.
Paragraph 55. Yes.
The question which arises before this court is in regard to the relief which can be granted to the petitioners. The final list of successful candidates was issued on 2017. The candidates who have been selected have been working as district and session judge for about 6 years. In the meantime, all the petitioners who are before the court have not functioned in judicial office. At this lapse of time, it may be difficult to direct either the unseating of the candidates who have performed their duties. Your Lordship will, then the conclusion part, Your Lordship will sign it. The following our conclusion. The principles of good administration require the decision of the public authorities must withstand the test of consistency. Number two, an individual who claims a benefit or entitlement based on the doctrine of substantive legitimate expectation has to establish the following: the legitimacy of the expectation. Here, their number, Your Lordship will kindly see, their number in the serial is much below expectation. They do not have any, they can't have any expectation. Then the last one, who in terms of the
There
relief
was someone
hold-
above them also who they have not made parties.
They
right?
have not mentioned. That is another aspect. Otherwise, their serial number is situated at 17.
Alright, can we have it on another date? Let me go through this. You have you also prepared something? Give it. You also give it.
I'll give all the citations, my lord. I have read.
Affidavit filed by the council is important because they have said, my lord, why respondent number 5 has been appointed and
This
what is
is
the
this
position.
is by the petitioner,
Yes,
My lord.
and this is by Mr. Das. R4,
yes,
R5.
5.
And there is one given on behalf of R4. You have given
I'm only depending on that judgment.
that judgment.
Paragraph 4
Yes.
of the affidavit in opposition filed by the council.
Para
Lord,
4 of
The
council.
council's affidavit. It says, my lord, what is the position?
All right, we'll have it on next Tuesday.
Well, on that, I'll supply them all the citation.
No, why don't you give it before that? You have it now?
Here the 12 judgment, my lord, with a list of, my lord.
No, you please ask your junior to just prepare an index whereby all the paragraphs and everything is
My lord, I have made.
given. You have given. এটুকুটা দিছে। Not included. Okay. That clip.
They have no chance of being appointed in the.
For the petitioner.
Judgment related by my lord, senior friend, my lord, it is not applicable because, my lord, that, my lord, there is a procedural, my lord. There is a violation in procedure, my lord, while preparing the list, my lord. In case of the, my lord, substantive violation, my lord.
So we take it that the arguments otherwise is complete.
My lord, my lord.
I think your affidavit someone had shown on that day. Oh no, that day you were not there, right? Correct. Your affidavit paragraph?
5, 6, 7, 5.
No, paragraph 5, 6. Para 5 and 6 of AICT. এই এইখিনি সবৰে নামখিনি দি দিবচোন আৰু এইটো fixed on Tuesday. List for further hearing on so and so. এইটো মোক দি দিব গোটেইটো এই ওপৰত লিখি দিয়ক. Let me make an endeavor on next Tuesday. Mr. Mohanto.
My lord. I have not insisting your lordship if lordship exhausted then one of the.
No, it's just that all the bail orders has to
Yes,
be
I
signed.
have seen well from morning I have noticed these things. Lots of cases.
Lots have been disposed.
Of and lots of criminal technicality also there.
Yes.
So,
What happened is that if it were writ petitions, then, one
jump
day,
over to another.
correct, one day more, the order can wait. But most of the bails have been granted. I think
Yes,
only
yes.
one rejected.
Yes, I have seen.
So that cannot wait.
That too after so many deliberation also there.
Correct. And in most cases, they have been inside for a long time. So it has to be signed. Any date.
6 May, my lord, also is possible.
6 May, due to paucity of time, and fix on 6. List again on 6 May.
Possible, always.
You were mentioning this matter.
Lordship.
Sorry, I have to keep you waiting. Could you manage to get hold of the other lawyers? Anyway, now since the matter is called, you wanted time for.
File affidavit in reply to the affidavit in opposition.
Okay, your name?
A. Chakravarti.
MSA Chakraborty, Learned Counsel for the petitioner, seeks 2 weeks' time. To file a rejoinder to the counter affidavit filed by respondent number 4. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry. Miss Counsel, I'm sorry that I had to keep you till the end, but you see, because there are so many advocates and name that has been shown, it's almost 1, 2, 3, 4, 5, 6, 7, 8,
Yes,
9,
Lordship,
10,
I have
11,
seen.
12, 13, 14, 15, 16, 17, 18 names.
And Lordship, I have
So unless you take consent and make a mention in the morning, it's difficult to accommodate.
Lordship,
Because
and
later they may come and say that they didn't know. That is why.
that I
No
mentioned
problem,
without-
no problem. Aisa?